USCIS announced this week that they're going to begin placing people in removal proceedings possibly. This is a change in practice for family-based adjustment of status applications. So if you have an I-130 petition filed and you have a 485 adjustment of status application filed, then they may place you in removal proceedings moving forward. This is a change in practice. It's not a change in law. Also, if you just have an I-130 petition that's been filed and maybe you're looking to file a unlawful presence waiver and do consular processing, that might also trigger being placed in removal proceedings. So this is a big change, because before they were not placing people who have adjustment of status applications, so 485 applications and I-130 applications, and they basically are eligible to adjust status. But now they're going to place you possibly in removal proceedings if you have an I-130 family-based petition and you have a 485 application. This is a big change. So what I anticipate is that they're going to be doing this for people who have any kind of arrest, who have overstayed possibly, or have any other kind of adverse facts in their case and their immigration history. So a few things you can do: if you do have any arrests, you want to probably seek post-conviction relief. If you can avoid filing your adjustment of status application before you overstay, then do that as well. That will prevent them from you falling out of status. So if you have some kind of status, you want to file the adjustment of status application before you fall out of status, because then that will basically lock you in and you'll remain in status while your 485 application is being adjudicated. So this is a very big change and policy. So you definitely want to consult with an attorney if you're in this kind of situation, because now if you file an I-130 petition, it could potentially trigger being placed in removal proceedings. And then you got to hire an attorney. I mean, obviously you can present that application in court, but then that becomes a lot more expensive, and it can take a lot longer to get a merits hearing, get a final hearing before a judge, and that's going to be an adversarial situation, as opposed to USCIS, where it's not supposed to be an adversarial situation. So that's basically the biggest update I've had to adjustment of status applicants this week. Couple of updates on that is basically one of them had a juvenile arrest from when he was 16 years old. He had been placed in removal proceedings. He later became a DACA recipient, and he hadn't disclosed that arrest in his DACA application, but then later during the adjustment of status application, he decided to make an informed decision to disclose it. Obviously there was no records, so when we went to court and we basically requested the records, it showed that there were no records for that. But he did, he made the decision to disclose it. But keep in mind, guys, if you have a juvenile arrest, you're not technically required to disclose it. It's a decision you decide to make, because they can't force you to basically give any court documents unless they get a court order for juveniles, at least in California. But other states, that's different. So that's one update. Another one was an overstay applicant who was doing a marriage-based. Luckily, people who are being processed now, so far we haven't heard of anybody being placed in removal proceedings. This is a recent announcement, but be careful, consult with an attorney. If you have an I-130 petition that you've already filed, maybe with a concurrent 485, or based on a family petition, or perhaps you're considering filing an I-130 petition, this is something to be careful about. A couple other updates is basically, unfortunately, did a naturalization interview earlier today, and the applicant was eligible for using a interpreter to basically have the civics test interpreted into their language, and they only got 5 out of 10 questions right. So make sure you're studying these questions. Make sure you're getting the 100 questions off the website and you're studying all 100 questions, because if you don't get at least 6 out of 10 questions right, they're going to stop the interview in the very beginning for your naturalization interview, and they will give you another opportunity, but it's only one more opportunity. And if you don't pass it the second time, then they'll just deny your naturalization application. All right, guys, if you need any help, reach out to me, rod@armandolaw.com. Take care.